Good afternoon, everyone. My name is Glendora Hughes. I'm General Counsel for the Maryland Commission on Civil Rights, the state agency that's responsible for enforcing the state anti-discrimination law, covering employment, housing, public accommodations, and state contracts. This afternoon's webinar is going to focus on employment law, and I have probably met many of you in other environments, but we want to provide you with going back to non-COVID type employment issues, as our title says, getting back to regular employment law issues, developments in discrimination, harassment, and retaliation law. Here I have my colleague, Parker Feeney. He is a partner with Shaw and Rosenthal. He practices in employment law and labor and human resources and multiple types of employment and labor type issues. He has contributed to several publications, and he's recognized by Chambers USA and Super Lawyers. And you can read both of our bios that are contained in the packet for additional information about us. You can move the slides. There's our disclaimer and the bios. You can move the slides past the bios. So what we want to cover today is looking at the current outlook. How is MCR functioning under COVID-19? Go into what are some of the recent and new amendments to state government article Title 20 that the commission enforces. And then we will go and talk about some cases recent cases that have been decided in over 2019, 2020, and discuss those issues. We want to have it more like a conversational piece. So if you have any questions that you would like us to look at and address while we're in a particular area, please add those into the chat, and we will try to field them as we go along. I will start it off, and Parker will chime in as needed, and vice versa. We'll both talk back and forth about the particular cases from the position of enforcement versus the position of defense. So that's the program that we hope to present, and hopefully it will be helpful to you. Next slide. So the laws that we will be covering and that may be addressed are, of course, Title VII of the Civil Rights Act of 1974, the American Disability Act, the Rehabilitation Act, Age Discrimination, Equal Pay Act, Genetic Information, Non-Discrimination Act. And you can also email your questions to Doris. And of course, Maryland will be, Maryland law is the state government article Title 20 under the Maryland Annotated Code, which is what we'll be discussing in Maryland law. These slides will be available, as well as the video of this presentation if you need to go back for reference or share with some of your colleagues. But both the slides and the presentation will be made available. Next slide. So some of the updates that I'm going to present are going to be the changes in jurisdiction and statutes of limitations and new definitions that were added to our statute last year and some this year. This non-disclosure agreement survey, just a brief discussion about that. And then one of the new law amendments to our statute, which will go in effect on October 1st, which would be the Crown Act, which expands the definition of race to include hair texture and hairstyles. Next slide. And those are the citations of the areas where the new amendments are attached. Next slide. So starting off in terms of in 2019, the definition of an employee was expanded to include independent contractors who heretofore were not covered, who the thinking was that these persons work in employment environments and who are harassed, may be harassed by persons that they're working in as consultants or independent contractors, but they have, because that is not technically their employer, they have no way to get redress. They had no way to file a complaint of discrimination. So a part of the packet of laws that were passed addressing sexual harassment, this definition was expanded to include independent contractors as an employee of the employer who they are working for, providing services for. Also, yes.
I'm sorry, Glendora, I was just going to jump in there and just add one sort of pointer from the perspective of employers on this expansion of the definition of employee to include independent contractors. Sort of encompasses a decision that employers have to make about whether they want to provide independent contractors with training and policies like they normally would for employees, so that employees have an avenue to bring complaints and understand the prohibition on harassment to their employer's human resources department, for example. That can be in tension with other reasons that employers may not want to provide policies or trainings to independent contractors, because they may, for other purposes, want to avoid the possibility of becoming a joint employer, for example, under Fair Labor Standards Act or the Maryland Wage and Hour Law. So it is something that requires employers to take a step back and reconsider the relationship that they have with independent contractors based on this amendment.
And you know, it does create a whole different dynamic, but I agree, you know, in terms of best practices, you may want to really look at that. And the independent contractor could possibly be the harasser. So, you know, you have that flip side in terms of a third party harasser in the workplace. The whole concept of sexual harassment best practices is not having a work environment that's free of this type of behavior in terms of both ends. As a person who is potentially employee, or in terms of the liability of the employer. So that is something to keep in mind as far as that expansion. And then another area where there was an expansion was the area involving those staffers who were worked for an elected official, a delegate or a senator, their personal staff, who are the people that you probably reach when you call a delegate or senator's office. They had no protection. And so the prohibition that was previously in our statute that excluded them from protection under Title 20 was removed, deleted, repealed, I guess the appropriate word, repealed, and provided that those persons too can file a complaint with us alleging harassment should they find themselves victimized, that they now have that protection. Next slide. So in creating this definition, one of the thoughts that came out during the hearings and the task force review was that many of the persons who were suffering really egregious sexual harassment were persons who worked for employers that had 15 or less, particularly those 1 and 2 employees where the owner is there and the owner is the harasser. And there was no recourse for those employees. They had no, because unless they lived in a county that in some of the localities do have a lesser threshold in terms of determining who is an employer, had less than 15, unless they resided in that county, they were just out of luck. And so the part of the package that came out of the task force was to provide coverage protection for an employee of an employer who had one or more employees. That was the thinking behind providing that protection.
And Glendora, on this point, you and I have talked about this. I know when I first saw this amendment, one of the things that came to my mind was that from a small employer's perspective, initially, one of the concerns that you have when you're facing a discrimination or harassment claim from an employee of one of these smaller employers is that you'll be faced with a tortious wrongful discharge claim under which there are no caps on damages, and the exposure can be much greater. That was found to be a viable claim in a case called Molesworth. And as we were talking about it, I sort of raised the point that, well, our employers, small employers, seeing more protection as a result of this, and you had a pretty interesting response to that. You know, in terms of the access that employees now have.
Well, yes. I mean, because Molesworth dealt only with termination, whereas there are other most folks will, particularly if they're working for a small employer, they need their job, and so they will put up with it, or they're not being paid fairly, or they're being threatened in terms of their ability to continue with their work. So the idea is that no one should have to work in that kind of environment, and that those persons are the most vulnerable in that there's no HR, there's no policy, there's no option for them to utilize to bring their grievance and protect themselves. And so the thinking was that, well, then there need to be a statutory protection for those employees. And it is limited. The reduction in 15 or less is limited to harassment cases only. Okay, next slide. And one of the thinking in terms of this is the first codification of harassment in our statute. Prior to that, there was no definition of harassment. The reliance was on case law, and the formulation of the definition of sexual harassment in case law was what we utilized and relied on, but there was no specific codification of the term harassment in the Title 20. Initially, the definition was going to be on simply sexual harassment. However, the committee, and as the legislation moved on, decided that it would codify a definition of harassment covering all protected classes, and not simply a definition covering sexual harassment, as well as the change in terms of number of employees. You see that the term is harassment and not simply limited it to sexual harassment. So all protected classes and all bases are covered under this definition. Next slide. So another thing that was added that, again, we were utilizing case law to define who was a supervisor. The legislators decided to codify that definition. And the codification of the definition of supervisor did not follow the definition that was set forth in the federal Supreme Court case of Vance v. Ball, which was much more restrictive of who would be a supervisor, meaning only the person who had the power to hire and fire and make the ultimate decision. However, following the prior interpretation before Vance, the state continued to had a much broader definition of who a supervisor is, and which they in turn codified by stating that a supervisor doesn't necessarily have to have the name, but if their acts or omissions toward an employee or applicant committed by an individual who undertakes or recommends, which is different than having the ultimate decision. But if they have the power to undertake or recommend a tangible employment action, and as you see, particularly those who work in state services where the secretary is the ultimate an agency is the ultimate decision maker, but you have deputies and management, middle level, who make these recommendations that changes people's terms and conditions in terms of their disciplinary action, promotion, demoting. Those people will be considered supervisors, and as well as those who direct, supervise, evaluate the work of the person as well would be considered. And then if the negligence of the employer led to the harassment, particularly when you knew or should have known that this was taking place, but you turned a blind eye to it and did not take an action involving coworker to coworker harassment type of thing, which one of the things that piggybacked into what the state did in terms of mandatory training for state employees, that best practices was that supervisors had to be specifically trained on what their responsibilities were as it applied to handling complaints that came in about harassment and also in terms of their own behavior, because many situations employers get in trouble because their supervisors are not properly trained, and they may be the first one that, particularly when it's coworker to coworker harassment, may hear about a complaint and do nothing, which then may create that liability. And so the best practices is that you train folks to know how to handle this thing, but also that as a supervisor, your behavior creates liability for that employer if you take a tangible employment action. So this is specifically codified in state law. Okay, next slide. And there was a change in terms of time limits and where people had to file the statute of limitations. The statute of limitations for a harassment complaint only was expanded from 6 months to 2 years in filing with the commission. So a person has 2 years to file a harassment case. It doesn't change the 6 months for all other actions, but for a harassment case, a person has 2 years to file. And as it comes to civil actions, a person, the expansion of filing complaint went from 2 years to 3 years to file a harassment complaint only. So you have those statute of limitation issues expanded for harassment specifically. Okay. Quickly, non-disclosure agreements. This applies to, next slide. This applies to employers who have 50 or more employees. And as a matter of public policy, the state is saying that waiving any substantive or procedural right or remedy to a claim of sexual harassment is null and void against public policy of the state. And it's in the labor and employment law article and not in state government article Title 20, but it's in the labor and employment law article. And this was a response again to the whole Me Too movement and dealing with the revelation from the media about these various serial harassers who were protected by non-disclosure agreements, that they continue to, after signing millions of dollars of settlement, continue on harassing after these agreements. The concern of both the legislator and the executive branch about protecting folks, protecting serial harassers by having these agreements in place, that they were going to be made considered void under public policy. But I think, you Parker, you had something in terms of how this affects the arbitration, the federal arbitration.
Right. So as many of you might know, a lot of employers ask their employees or require their employees to agree to arbitration agreements, and consideration of this new provision is important. While there may be some tension between this provision and the Federal Arbitration Act, looking at this provision and the fact that it would render an entire agreement void if it waives a procedural right or remedy regarding a claim of sexual harassment, there's an argument that an arbitration agreement would waive such a procedural right. So employers need to be cognizant of both this provision and the Federal Arbitration Act, and be thoughtful about how the two interact when preparing arbitration agreements they're asking their employees to sign.
Excellent. Next. This talks about prohibiting retaliation on the part of the employee because they refuse to sign such a waiver, and changing the terms and the conditions in terms of them refusing to sign such a waiver that's prohibited. Next slide. And attorney's fees if the person has to defend themselves against the employer for refusing to sign that waiver. Next slide. And another provision provided that there needed to be, they wanted a survey. They wanted to find out how many of these agreements are out there, and they created a survey that employers 50 or more had to fill out and file. Next slide. There were two dates, was July 1st of this year, and then the next reporting period is July 1st of 2022. Of course, the reporting period has closed for July 1st, and the survey for that period has been cut off. It automatically cut off on July 1st. However, we still are taking, if people send us their survey after the July 1st date, we're holding those because we're supposed to provide a report to the General Assembly in December of the data that we received from the filling out of these surveys. So the next due date is July 1st of 2022. Next slide. And this is just basically the questions that you can read those. Those are the questions that are on the survey, which we took from the almost word for word from the statute, so that we were making sure we were asking the questions that they were asking for. Next slide. The Crown Act, definition of race, hair texture, and it expands the definition of race in Title 20 of the state government article. Next slide. So here specifically, it defines race. It adds a definition for protected hairstyles. Race will now include associated with race, including hair texture, Afro hairstyles, and protective hairstyles. And protected hairstyles were described as to include braids, twists, and locks. This was a national movement that you had various law review articles that were written by law professors involving the interconnection and intersectionality of race and hair, particularly with Black women who were prohibited or were threatened with termination or weren't even hired because they wore their natural hair. You can see now that as this movement grew and there were laws being passed in various states, California, New York, New Jersey, there are several other states who passed the Crown Act, as it was labeled, to prohibit it. I know we received complaints along those lines, and we weren't able to take them because the definition was not, did not expand or include that. Even though we argued that it did, it was specifically included. So having this codified and specific in the law makes it unlawful to treat differently or to prohibit a person based on race because of their wanting to utilize and wear their natural hair. And you can see some of the demographics changing in terms of the media, where African-American women were basically told that you need to change your hair to be straight. in order for you to be on the air. And actors and actresses had to don wigs and or have their hair chemically changed in order to be able to have jobs or to keep jobs. And now that this movement and legislation have being passed, there is that protection, and you're seeing more and more persons of color who are utilizing and wearing their natural hair. And also it connects with the styling of that natural hair that was previously prohibited under grooming standards that employers had that were very limited and very restrictive, that cost women their jobs and or prevented them from being demoted or even hired because of their hair texture and their hairstyle. So it is come October 1st, this will be a part of the definition of race and would be prohibited under state law. Next slide. So now I'll turn it over to Parker, and we're going to, well, before we go in terms of into the cases, are there any questions that anyone has that what was presented that you may want to discuss, have us discuss further? Okay. Seeing none. Parker.
All right, thanks, Glendora. And so from here on out, we'll be reviewing some recent cases. Glendora and I went through a lot of cases and tried to pick out those that were the most interesting. And I'll provide a brief summary of the case. You'll see on the screen for each of the cases, the description of the facts, the holding, and sort of what we thought was a good bottom line for folks to take away from the case. And then I'll ask Glendora to share some of her perspective, and I'll share some of my perspective. And if anyone in the audience wishes to share their perspective or ask a question, please feel free to do so. Our hope is that we can have a nice little discussion about each of the cases. So to start this case, Parker v. Rima, this is a case involving rumors that a female employee was promoted because of a sexual relationship with a manager. These cases are not uncommon, and cases that revolve around rumors about employees engaging in romantic relationships in the workplace come up time and again. And one of the things that you will often see, a defense that was raised in this case, is that the rumors were not sex-based because they were based on the conduct of an employee, not based on her sex, or that the rumors were not sex-based because they were rumors about both a male employee and a female employee having engaged in a romantic relationship. But here the court determined that that was not the appropriate analysis, deeming that the perception that women and not men would need to use sex to achieve success was really at the core of the rumor that was being spread throughout the place of employment. And analyzing another aspect of the prima facie case of harassment that the employee set forth was whether the harassment was severe or pervasive, and the court found it to be both severe and pervasive, given that it was frequent, humiliating, and directly impacted the employee's work environment, resulting in her being shut out of meetings and ultimately disciplined and terminated from employment. So our bottom line for this case was that employers need to be cognizant of the spreading of false rumors within the workforce, and not think that they can rely on a straightforward defense that rumors are just not sex-based in nature and will not lead to potential liability. So Glendora, I'll ask you if you have perspective to share on this case.
Yes, this and you probably have heard or experienced where when it comes to a woman progressing and moving up, that there is sooner or later someone is going to put that rumor out that, well, she didn't get it on merit. She slept her way to the top. Just last night I was looking at a post on a news post on Facebook, and I was reading the comments. The news post was about the selection of Kamala Harris as VP, running with Joe Biden, and several of the comments was, "Oh, she slept her way to the top." I was mortified. Like, based on what? This woman had to run for multiple offices on her own merit. And the only response in terms of attacking her was she slept her way to the top. So this is one of the, deadliest and most serious thing that, that you ruin somebody's reputation, and it's difficult to refute when people hang on to it. And then the teachable lesson is that the employer, cannot buy into that and be participant, like some of were here, in spreading that rumor or blaming the employee for having a rumor being put around against her. I mean, she's between a rock and a hard place where she's being falsely accused, and then she's punished by the employer for being falsely accused. So that was the concern in terms of why the Fourth Circuit looked at this, because of the harm and the prevalence of trying to use this kind of sabotaging of someone's career as a rationalization of why they got a justly earned promotion or advancement, and the person knowing that nothing creates more of a hit than starting a rumor that, oh, she didn't get it, she didn't deserve it on her qualifications, she got it because of she slept her way to the top.
Yeah, I might add one additional practice pointer for employers here on the subject of internally investigating claims of harassment. In this case, both the employee who ultimately became the plaintiff and this so-called jealous coworker had made complaints about each other. And to me, this case highlights both the difficulty of investigating and resolving complaints by one employee against another and vice versa, as well as the importance of an employer being able to understand the underlying claims that are being made by each of the employees, thoroughly investigating and coming to very well-reasoned conclusions. Not to say that that will eliminate the likelihood that litigation follows, but it certainly can go a long way toward reducing the likelihood and potentially mitigating the exposure.
Yeah, exactly. And particularly in quashing those rumors and making it, a prohibition for people to be spreading personal rumors about people in the workplace, because it does have these very serious consequences. If you create a culture and environment where that is allowed, then you're potentially putting yourself in that kind of exposure. But if you shut those things down and address it, as a matter of policy and a matter of culture, that we're not going to have this, that bodes well in showing that you're not complicit in this type of behavior.
Okay, I think we can move to the next slide, please. And so continuing on our initial topic of harassment, this case is one that I think both of us found to have a unique set of facts, but a defense that's often raised by employers. In this case, we had an employee who alleged that she was one of the most successful managers of one of the employer's medical facilities. She's then diagnosed with a very serious illness, and one of the doctors employed by the employer both provided care for the employee and engaged in a romantic relationship with the employee, and was alleged to have proposed this sort of secret affair along with a promise to protect the employee's job. Interestingly, while this was a motion to dismiss filed by the employer, it also submitted text messages and styled its motion as one for summary judgment in the alternative. And the court, citing some of these text messages, cast significant doubt on whether the affair was not consensual. And Glendora and I will make some points on sort of what can be deemed welcome or unwelcome when it comes to that element of a prima facie case of harassment. But in this case, the court held that the employee's quid pro quo sexual harassment claim would survive because she had adequately alleged that the doctor promised to exchange job protection for engaging in this romantic relationship. On the other hand, in contrast to the case we just discussed, the court dismissed the hostile work environment claim because coworkers were not generally aware of the affair, and the work environment was not, as the court said, permeated with discriminatory intimidation, ridicule, and insult. So this is in contrast to the case where there were rumors that greatly impacted the employee's job. In this case, there were no rumors. It was not something that folks were really aware of, and so the court dismissed the hostile work environment claim. So our bottom line here is that romantic relationships between supervisors and subordinates, even if they're consensual, can pose significant legal risks to an employer. And so maybe Glendora, let you sort of share your perspective on this case, and I'll share some of my perspectives as well.
Yeah, one of the things that you're looking at prior to the Vincent versus Merida Bank, that case talked about the difference between consent and welcome. And when you have this superior and subordinate type of relationships, there is a question about whether or not it's welcome, whether or not the person is consenting to the relationship because the person has the subordinate is susceptible to possibly suffering an employment action against them if they refuse. In this situation, it was very difficult to determine, whether or not that it was not welcome. It seems that it was, but it does. Supervisors with these, employers having these kind of relationships are in danger if it goes bad. Which is where you end up with these kinds of challenges where somebody wants to, the supervisor doesn't want to let the person go. The person wants to end the relationship, and they're being continuously pursued by that supervisor. And the supervisor creates the liability for the employer because they are in that position of power. And if they do take any kind of action against that subordinate, it's going to be viewed as that the relationship was not welcome, is that the person only participated because and only consented because of the fear of losing their job or the fear that they won't get the benefit, i.e. the promotion, or in this case, being protected and having continued employment. So that's the quagmire in terms of having these workplace romances, particularly when you have an imbalance of power between the two parties.
Yeah, I I completely agree. I think that disparity in the relationship often causes a lot of consternation among management side employment lawyers. And here, when it came to unwelcomeness, I will often say, silence or acquiescence to a proposed secret affair, as in this case, is not necessarily indicative of welcomeness. And the court, alluding to that, really looked at whether these text messages were indicative of, instead, an employee who was initiating the affair or the romantic get-togethers with the doctor. And I think that also highlights an important evidentiary issue for us in these cases: the advent of text messages and how frequently they're used to communicate, deeply personal things between coworkers. It's a critical evidentiary aspect of cases like this, and it's not the only evidence, of course, but it's meaningful because oftentimes exchanges that would otherwise be in person or over the phone are in writing and can be used either to undermine a claim or support a claim, depending on what the messages might show.
Yeah, definitely. And in this age of technology, people forget they're creating a record when they're emailing and texting and Instagramming. Just because you delete it don't mean it's gone. Delete doesn't mean delete. It's on the server. And that's one of the areas we go look for when we're investigating. We're looking for the technology. We're looking for those text messages. We're looking for those emails because that's, the norm these days in terms of how people, particularly in the younger generations, how people communicate with each other. And, you're looking at, is this unwelcome behavior, and whether or not it was consented to because the person feared that they would lose their job or they would suffer some other employment action.
Okay, I think we can move to the next slide, please. So again, on our initial discussion theme of harassment, this is moving from sexual harassment to race-based harassment. Glendora and I thought this was particularly relevant and timely at this moment. This case really deals with what I think the court really properly identified as coded racism. In this case, the allegation was that a white female executive director used terms like "you people" to refer to Black employees and referred to the majority Black board as acting like animals, as well as giving an African-American employee a card with monkeys on the front of it. And while there was not an allegation that the N-word was uttered or any racial epithet that we would typically see and universally cringe at, it was the use of this widely recognized coded language that the court took issue with. The employees' hostile work environment claims did survive summary judgment because the court deemed the protection against a hostile work environment based on race to extend to the dog whistle and coded racism that was identified in this case. With regard to whether the element of severe or pervasive conduct existed, the court said that determination be left to a jury. So what we came up with for a bottom line here was that both subtle and less subtle language that's racially charged or has historically been used in the context of coded racism will likely result in a successful hostile work environment claim. And Glendora, I know one of the cases that you and I discussed was the Fourth Circuit's decision in the Boyer-Liberto v. Fontainebleau case. So I don't know if you want to elaborate a little bit more on your perspective on that.
Yeah, it was against the the Clarion Hotel where the bar has its annual meeting at, and they the employee worked in the restaurant, and the supervisor proceeded to, because she was unhappy with something she did, referenced her several times as a porch monkey. And the court said that that term was as egregious as if using the N-word for looking at whether or not this was a hostile work environment, that this was, again, one of those coded terms utilized to demean and to harass an African-American woman who was working in the restaurant, and allowed her claim to go forward. And so the thing is that, people are saying, oh, it's 2020, there shouldn't be, this doesn't happen. Yes, it does. And it again, as you see, it's done you're not going to find that maybe rarely the out and out use of the N-word, but now there's coded language that is used to refer to people and to address people, to make it very clear of, I'm demeaning you and you're less than, and this is why, I don't respect you as a person and as an employee. And the court is saying that this, in the Fourth Circuit and in the district court, that this is not going to be allowable, and that people shouldn't have to work in that kind of environment. And we would consider this to be a hostile work environment. And in terms of, we would look at that and analyze it as a hostile work environment in the workplace.
Right. And I think that this, from an employer's perspective, is an important opportunity. Certainly the allegations in this case do not strike me as indicative of implicit bias, but an opportunity to train management and really all employees on what the bounds of the workplace harassment laws really are, and that conduct like this is not going to generally be accepted, and that going even beyond that, there needs to be an understanding and education about what sorts of behaviors and terminology really can cause significant offense, so that folks have a thorough understanding of what's going to be accepted in the workplace and what's not. Okay. I think we can move to the next slide. Okay, so this is I think our final harassment case, and the case involves a gender identity claim. And in this regard, in this case, the employee identified as a male at the time of hire and subsequently transitioned to female during employment, was told that her skirt was too short by her supervisor. And I think, to me, one of the critical aspects of this case is that she alleged that she was routinely misgendered. In other words, her female name and female pronouns were not used. Rather, she was referred to using male pronouns. And the court in this case held that being subjected to misgendering a handful of times was sporadic and not extremely serious, and that the comment regarding the short skirt, while it may have been more serious than misgendering, was not sufficient to support a claim of hostile work environment. So here, there are a few bottom lines, I think, that we'd like to discuss. So first, although discrimination based on gender identity has been unlawful in Maryland for years, as you saw in the slides that Glendora presented, it's a protected category that's expressly identified in the statute. The U.S. Supreme Court just recently held that Title VII prohibits discrimination based on gender identity as well as sexual orientation. And I believe the MSBA recently had a presentation on precisely that case. From my perspective, I would expect that these sorts of claims are going to become more common, and that misgendering is going to be an issue in many of the claims. And we both see the misgendering issue as turning on whether misgendering is intentional and frequent or accidental and infrequent, insofar as hostile work environment claims go.
Right. I think the court looked at, was it sufficiently severe, or was it pervasive enough? Well, it didn't find it to be sufficiently severe, and it found that the misgendering happened a handful of times based on what they were presented with the evidence, that it was sporadic and it wasn't a consistent to establish that it was being intentional. Some of the challenges that you have to look at, particularly if you have a situation where someone who was working there as a male and then transitioned into female, that the coworkers know this person as a male, as opposed to them just coming there as a female. And so I think the court sort of gave some leeway in terms of the handful of times of misgendering that people are still trying to make that adjustment, and that whether or not there's sufficient evidence that they were intentionally miscalling the employee on purpose. And that's what you would have to show, is that there was an intent to misgender the person, regardless of what the person established who they are, that there was intentional and that it was pervasive, that it just went on and on and on. So, the facts of this case sort of shows you some of the issues that you would encounter when you're dealing with gender identity, when you're dealing with persons who are transitioning. This is sort of like a different topic that from what you usually see with that we see is usually the bathroom issue. But here you have that shows you there are a wide range of issues that can occur involving gender identity, that includes the type of how that person is being addressed and being recognized as.
Okay, I think we can move to the next slide. So the next case involves reasonable accommodations, and I can tell our time is short, so my summary of the case will be brief. Here, the employee was seeking an accommodation, and the case really boiled down to whether the employee would have to compete for an open position, or whether there should be a non-competitive transfer or reassignment into an open position as an accommodation. And some of the background in this case regarding the Maryland law versus the federal law, the Court of Appeals in this Adkins case that you see referenced held that Maryland law requires employers, as part of the interactive process, to search for vacant open positions rather than putting the onus on the employee. And this case then makes clear one additional step that employers need to take, and that's once an employer has identified the position, as long as the employee is qualified, the employee will be entitled to a non-competitive reassignment into the position. And I will say this is a very interesting case. There's a very thorough analysis of whether the ADA requires a non-competitive reassignment, and discussion of instances in which it may not. I encourage you to take a look at the case, but I think to us, the bottom line was these two components under which employers need to ensure that when there is no other accommodation, that they're first searching for an open position, and second, if they find one, it's a non-competitive reassignment.
Right. Those are the teaching points, because employers have gotten into trouble when we look at cases, is where they tell the employee, go find yourself a vacant position. And the court said, no, you're the one that knows where the positions are. You have to find it. And then the other piece where we see violations is the employer saying, well, the complainant wasn't the most qualified person for the position. And the law says that they don't have to be the most qualified. As long as they are qualified, then reassignment to that position is the reasonable accommodation.
Okay, we'll move to the next slide, please. So these three cases we won't go into in detail, especially considering that we're short on time. But they are each cases representing employees successfully proceeding with their pay equity claims, whether it is a claim under the Equal Pay Act or a discrimination claim under state or federal law. Our bottom line here is just that pay equity disputes are becoming more common. And when you have employees who are performing the same duties and are in different protected classes, but are being paid differently, it's really important to have a very compelling reason for them being paid differently.
Right.
Glendora?
And also, if you are one who is possibly bringing a pay equity case, there are several laws that cover it, not only state government article Title II for differential pay, but there's also the state Equal Pay Act that you can also look at, as well as a federal Equal Pay Act. So you need to look at those three different laws to see what is the best law to file your claim under that affects the facts of your particular case. And they have different filing times. They have different statutes of limitations. So you don't want to miss out on a particular protection that the case may better fit under because you didn't look at those other statutes.
Okay, thank you. Next slide, please. So this case, EEOC v. MVM, there are sort of 2 points that we wanted to make about this case. The primary discussion point here is with regard to the EEOC's conciliation process. So when the EEOC makes a finding that there's reason to believe that discrimination occurred, it then moves toward the conciliation process. And in this case, the employer claimed that the EEOC failed to meet its conciliation obligation because in the conciliation process, the EEOC adopted a take it or leave it approach to negotiation. And the court made clear that it does not have the authority to question the negotiation tactics that the EEOC chooses during the conciliation process. And it doesn't even get into what the communications between the parties were during that process. Instead, the bar is low and was set by the Supreme Court that the EEOC really only needs to show that it informed the employer about the allegation and that it engaged in some form of discussion to give the employer an opportunity to remedy the discrimination. So here, where the EEOC said, this is what we're offering you and there is no other alternative, the court said that it had met its obligation. So our bottom line here was that employers should not view the conciliation process as one in which the commission must negotiate. It doesn't. The commission is not going to be obligated to respond to every counteroffer that an employer makes during the conciliation process. And I think Glendora can elaborate on her perspective on employers that take very aggressive approaches to negotiation. But before I turn it over, there was one bonus practice pointer from this case in the decision in this case addressing the merits. The allegation was that the employer hired a manager that discriminated against employees based on their national origin, that the employees that the supervisor believed to be of African descent. And one of the defenses raised was that the discrimination, some of these folks were not in fact African, and that the discrimination had to be based on actual and not perceived national origin. And the court declined to accept that argument, finding instead that the employer's mistaken belief that these folks fell into a particular category was sufficient to state the national origin claim. Glendora?
Yeah, and we have a process in terms of once probable cause is found that conciliation is attempted and failure conciliation leads to certification for public hearing or case to go to court. And you can have situations where, it's just dragged out, or you have a situation where the complainant is asking for more than what that's allowable. The minimal jurisdiction requirement is that we attempt it. Here's the finding. What are you offering to remedy the situation? And if your offer is basically a nuisance offer, then there's no point. There's no point in conciliation in good faith. We're not going to edge up $2 here, $1,000, because we'll move on to litigate, which is basically what the court is saying. One, you shouldn't have brought this conciliation issue and these documents before the court. And we're not diving into figuring out whether it was a good offer or a bad offer, because it impacts and has a chilling effect on trying to resolve these kinds of cases. And the court is erring on the side of, we want these cases to be resolved, and we're not going to get into the weeds of that activity by EEOC.
Okay, so we'll go to the next slide. I realize we're at the end of our time, but this was a case that Glendora and I both agreed we could probably have talked about for the full hour. So I do want to just hit on it real quickly. The bottom line in this case is that when you are confronted with a failure to hire or failure to promote claim, one of the elements of a prima facie case that an employee has to make out is that the employee applied for the job. And the holding in this case, I think, is particularly important in our current time of focus by employers on diversity, equity, and inclusion, and revisiting our recruitment and hiring and promotional practices. In this case, the court held that if the promotional system is informal and opaque, then a formal application to the position is not going to be required to establish a prima facie case of failure to promote. So where you have employers that may be hiring people in a supervisor's personal or professional network without posting a vacancy and accepting applications, or promoting people sort of based on word of mouth within the company, those sorts of promotional or hiring systems are going to likely lead to a employee being able to set forth a prima facie case without having formally applied for the position. And in this case, the employee did express an interest in promotion despite the failure to formally apply. So the bottom line being that the manner in which employers recruit for open positions has an impact not only on whether the employee can establish a prima facie case of discrimination, but also an impact on the diversity of the workforce more broadly.
Right. Yeah, it's these informal processes that prevent diversity. If you're not in the network, you never know there's a vacancy. You just keep seeing people coming in. As she was seeing managerial positions being filled, but never being made aware of whether or not those were open for her to apply for. And she made it known that she was interested in being promoted and being a floor manager. And she was basically ignored. And basically they did an end around by not even telling her that these spots were available. And so as we look in terms of trying to look at diversify places of employment, this is one of the areas these informal processes have to be looked at, and also where you recruit. But more importantly, not just recruiting and getting people there, but keeping them there. Because if the inclusion part of diversity and inclusion many times gets dropped, because the focus is on hiring and include, look who we hired. But how many people did you lose because the culture didn't change and that the people didn't feel welcome, and so they didn't feel included in the work environment, and so the person left. And so the important lesson is that one, when you're looking at in terms of diversifying your workforce, that it's not only simply the job is done recruiting and hiring someone, but keeping them there and looking at your environment, your work environment, is it welcoming and is it inclusive to the people that you have recently hired? And that's one of the important takeaways.
Okay, I think we can move to the next slide, which I think is our invitation to ask any questions. I don't believe we have any, but if anyone has any questions, we're certainly happy to answer them at this time.
Okay.
All right, well, thank you everyone for attending. Appreciate your time and attention, and so long.